praise him till I'm gone. When the praises go up, the blessings come down. When the praises go up.
I'm Christy White.
And I'm Odunukwe.
And this is
The Tea of Immigration.
Girl, hot tea girl.
Oh, yeah.
Real hot tea girl.
Real hot.
Started.
All right.
So there has been a lot going on in immigration, as you know. We have a couple of hot topics that we just gonna, refresh you on and let you get a better understanding, because we all know that law linguistics can be really difficult to understand.
Yes. So Jeff Sessions and the Trump administration has been very busy.
Mm-hmm. And as you know, I don't know, girl, have you seen the memes of him looking like Gollum?
I haven't, but you're gonna have to show me.
Girl, on Lord of the Rings, if y'all know who Gollum is, that's who he looks like with them ears, and when he be smiling from ear to ear, and I be thinking, boo, you looking like Gollum. However, he does remind me of his evil spirit as Gollum, as in him overruling the matter of A and B.
I think I'm gonna have to watch Lord of the Rings.
Girl, you're gonna have to watch
Lord of the
Rings.
I'm a little.
I mean, it's really long, so you're gonna need some time.
Okay.
But it's good. Do you like the Harry Potters?
I've never watched Harry Potter.
You have never seen Harry Potter?
No, because I wasn't allowed to.
Oh my God, my mom was like that too.
Yeah.
She was like, you can't bring that book into this home, and it's about witchcraft, and this is the Ward's house. And I was thinking, but Mom, it's fantasy. Like, you started.
All right. So first, we are going to talk about matter of AB.
Yes, and all that it encompasses. Thank you, Mr. Sessions, so very much.
So, where do we start with this?
Okay, matter of AB is a case law that has overruled matter of RARCG, if I'm not mistaken.
And really overruled anything that is contrary to what it says in there.
Exactly.
And what does it say?
So, it's pretty much stating that if you are seeking asylum, you can no longer seek asylum based on domestic abuse or gang violence in the United States.
And the rationale was that, so let's say this. When you're seeking asylum, you can seek it under one of 5 different protected categories: race, religion, nationality, political opinion, and membership
in a particular social group. A good example of membership in a particular social group is Guatemalan women were allowed to enter the United States if they were abused by their Guatemalan husband or spouse. This being that they have had a systematic political setup where it was patriotic and men could abuse women, and their government pretty much did not care. So the United States, in matter of ARCG, pretty much allowed them to come into the United States and seek asylum through that remedy. Now,
no longer anymore, and it was already really hard to have an asylum based on particular social group claim, but now what that decision basically says is that's no longer permissible. And not only that, it raised the standard for government's inability or unwillingness to protect
their citizens, pretty much, to protect their own citizens. And I just want to state, there are a lot of Central Americans right now coming into the United States, and they're claiming, and I think that they're true for all intents and purposes, gang violence. Hehowever, this case pretty much shut that door off. Whereas you could at least get your clients some type of time, go to the hearing, get them an EAD card, allow them to work and live in the United States for a specific amount of time. Just because cases do take a long time.
Yeah.
Now you're no longer to do that. You're no longer able to do that.
Has this affected you at all? Like any of your cases?
Yeah, actually, yeah. Whereas I could claim gang violence and try to, at least get that person an EAD card. Like I said, get my client an EAD card. Now there's other routes. You have to become creative, think outside the box. And even then, that's very limited.
Yeah, and there's a thing called pretermission. And so what we're seeing now is if you have a gang violent or gang-based claim, your client's case may not even get to be heard.
Mm-hmm.
It can be pre-terminated at the early stage once they hear gang violence or anything like that. So that's kind of what is happening, and it's scary.
Yeah. It sucks because people, like, honestly, people think there are a lot of Mexicans that are flooding the border coming in. And honestly, that's not really the case. However, there are a lot of Central Americans that are coming into the borders. And that is because there are gangs like Mara Salvatrucha, Mara 18, that were... MS-13, that was founded in LA and were deported to those respective countries. So now you have those gang members going into the community, raiding the community, colluding with the government. And you have our government saying, oh, well, we don't care.
We're not a fix-it-all,
yeah.
as Jeff Sasson said. So, yeah, that's...
And as Melania Trump says...
We don't really care. Do you?
Exactly.
Yeah.
So
speaking of Melania and her jacket, what do you feel about separation of families, and what do you have to say about that?
So there's been a lot of media coverage based on the separation of families, and thank you for everybody who has been putting it out there, retweeting it, getting the word out there. It is best to do that throughout the media to let people know what's going on. But it's just ridiculous. It's horrible. As I stated, and I state to other people, this isn't the first time we've seen this in America. African Americans experience this exact same horror. And it's traumatic. And it's kind of like, how do you guys think this is going to play out? Like, what do you think is going to happen? Like, to be that naive to history, to me, is ridiculous. And it should not be a quality that we see in our president.
Yeah. And even though it's, he signed the executive order, it's still happening.
Yeah.
So,
yeah.
I guess we're going to see.
And we've seen how they've made a solution to this. They've decided to put up and build many detention centers, even detention centers for kids. I think they're building a detention center for kids in Texas currently. So it's just like everything's just a moneymaker to them. It's just about green, I'm not sure if you guys watched Orange is the New Black. But immediately, oh my God, when I saw they were building, wait, did you watch the season finale? Let me not spoil it for you.
Yeah, don't spoil it. Okay. And spoiler alert.
Spoiler alert. Okay, I take it back. I won't say anything, but you totally got to watch it, and we're going to have to talk about it the next time we're here. So let's segue into other hot topics.
Okay.
Sips tea. Okay, administrative closure.
Okay, Christy, what is administrative closure?
So, administrative closure is like, let's just describe it in other ways. Let's say we're playing tennis, all right? Mm-hmm. And one court belongs to USCIS and one court belongs to the court, okay? Administrative closure allowed a person who was in the United States more than 10 years or so, or a person seeking a type of visa where they needed a waiver to forgive them
for
entering
example,
illegally.
Okay, so that would be through the border without a visa, without inspection or admission. Okay.
Mm-hmm. And it allowed them to have the court be taken from out of the ball be taken from out of the court's hands and put into USCIS hands in order to adjudicate their waiver or petition to forgive them for entering illegally, and then throw the ball back to the court so the court can then say, all right, we'll accept your application.
And how long does a waiver usually take to be adjudicated?
About 6 to 9 months.
Okay, so
6 to 9 months.
This made sense to be able to close.
Put a pin in it. Put a pin in your.
Okay. And let United States
USCIS
Customs and Immigration Service adjudicate that waiver and then bring it back to the court,
to decide on that petition.
Okay, so this is no longer on the table.
No longer on the table. It's gone. Gollum, Jeff Sessions, was like, nah, Obama administration, we can't let this fly. We're going to have to go ahead and cut this right here, right now. This is undermining what our intentions are for the future of immigration. And no,
So it's off the table. And now if, let's say someone has, someone who entered through the border needed to adjudicate, for example, an I-130 because they're married to a U.S. citizen, and they don't have this administrative closure and they need a waiver for that unlawful presence, what would happen now?
They would have to take a VR.
And what is VR?
So a VR is the voluntary removal, to voluntarily remove yourself from the U.S. back to your respective country. And I've actually had an issue with that. A client of mine, we were crazy scared because his hearing was in a week right before that decision was made. It kind of just really threw everything off. Whereas we were expected to take an administrative closure and then go ahead and submit for the waiver. The course of his entire case changed. I had to call him and tell him that, we had to take a VR. And in his instance, that was really scary because he couldn't go back home. He had an asylum claim just escaping from home.
Oh, wow.
Because of his sexual orientation. So, and being in a Central American country. So it was devastating. And
could a judge just continue it for 6 to 9 months to get the waiver adjudicated?
It just really depends on that judge. Most judges would not.
And judges now have metrics that they have to. So they really want to, because the immigration system is so backlogged, they're under a lot of pressure to move the cases along. So it really does just depend on the judge and
where you are and where you're located. And that's why we say it matters where you are, where your case is, because this is the Fifth Circuit, and the Fifth Circuit is located in the South. And if you know your history, then the South is the Bible Belt, and they're very conservative. And I'm gonna let that be that. Keeping it on moving then.
All right.
So, how do you pronounce the Pereria decision?
I believe it's Pereira.
Interesting.
Pereira. It's Brazil. It's a Brazilian foreign national's name.
Okay.
And this one's really interesting, actually. So in immigration proceedings, there's something called cancellation of removal. There's two forms of cancellation of removal. It's cancellation of removal for permanent residents and non-permanent residents. You need 7 or 10 years of physical presence in the United States before you can get this
visa, before you can be eligible for your eligibility.
Exactly. So there's something called the stop time rule.
Okay.
And there's 2 ways that time can be stopped. The getting a notice to appear, which is what begins the court's proceedings, or commission or conviction of a crime, whatever comes first. So in this case, this gentleman would have been eligible for 10 years of physical presence if he
had properly received his NTA. In this presence, the NTA was served. However, it did not have a specific time or date, and was not served to the correct address too. I think it was served to Martha's Vineyard, and I was thinking, this nigga living in Martha's Vineyard. Okay,
it's really nice out there,
right? Yeah.
So yeah, and so the government basically gives you this, let's say, this notice to appear, and they tell you need to appear, but we're not going to give you a time or a place.
Exactly.
So the Supreme Court said nah.
The Supreme was like, no. Okay, so the BIA was like, yes, this is proper law.
And what is the BIA?
The BIA is the Board of Immigration Appeals.
Okay, so just a little background. You have your immigration court, then it goes to the Board of Immigration Appeals, then the Fifth Circuit Court of Appeals, and then I think it goes back to the BIA, or we'll get back to you on that.
But that's not the point. The point is that is the pipeline, okay? Yeah. So before you even, the Supreme's not going to touch it. It has to go through like a ton of different pipelines before the Supremes touch it. But the Supremes was like, no. Okay, like y'all it's not reasonable to tell somebody, tell somebody a time.
Why did it take until the Supreme Court to say, it's so basic to me, like, you have a notice to appear, but it doesn't have, that's like giving you a wedding invitation and then not telling you where and when to go.
And then you're going to tell me when I don't show up that you're going to order removed in absentia. Like, but you ain't tell me where to go.
So thank you, Supreme Court, for
We appreciate it, the
just,
Supremes.
you know, some common sense, some logic.
I mean, we do want you to obviously push out a lot of other legislation, like, just side note, Roe v. Wade. Like, for real though, do we really even have to bring this back up? But, you know, that's just our take on
Travel ban 3.0.
Like, really though?
We didn't like that.
No. Mm-hmm. What were you thinking?
But on this one, you did a good job. So basically, this has created a lot of confusion for practitioners, because this is notice to appear is what usually begins proceedings and jurisdiction, and so people are really thinking that it transcends further than the stop time rule and the cancellation of removal. So a lot of people are moving to have their cases terminated because without a proper notice to appear,
I wasn't ever served.
Yeah,
I wasn't properly served.
So I guess we'll keep you updated on that.
Definitely.
Kind of see what happens.
All right, so on talk about Omarosa a little bit.
Oh Lord.
So how do you feel? How are you feeling about this new book that she has out? I've been seeing a lot of interviews of hers on the news.
Are you guys gonna buy the book?
That's interesting. We do want to hear.
Yeah.
We want to hear some comments, guys.
Yeah.
Are you guys gonna buy the book? I've heard that it's a lot of fluff. I've heard that she signed a non-disclosure, so she can't really release any details. So it's just basically saying that he's racist through this person.
Telling us what we already know.
Exactly. Thank you, Omarosa, for being a spy, I guess. Like, really, Omarosa? Really, though? Anyway. Just for you to know your rights, there was a new law that affects students, F1 students.
Oh, yes. So F1s used to be, they had what's called DS, or duration of status, meaning you come in and as long as you're within that status in school, then you're not accruing unlawful presence. So now, I think the memo was August 9th memo, F1s can accrue unlawful presence, and this is if they fall out of status because they couldn't pay for school, for example, or whatever other reason, or doing something that's against their status, they can begin accruing unlawful presence without even knowing it.
Oh, wow.
Yeah, so
that's crazy. And then it's not like USCIS had an alert to tell these people that, oh, by the way, you know, if you drop out of school, you accrue unlawful presence, and that's actually a negative thing, you know, while you're trying to or find ways to remain in the United States. You know, that's another thing that you're gonna have to try to defeat, which makes it even more difficult. But we wanted to say that it is really important that you vote on November 6th in the Texas State Senate election. We don't care, or we do care who you vote for, but obviously it is of your choice. But we do think that, it's important for your voice to be heard.
Yeah, and so if you need more information on that, we can post some underneath.
We'll post it underneath our link.
Yeah. All right. Thanks for watching.
Thanks for listening.
Just come down. It seems like blessings keep falling in my lap. It seems like blessings keep falling.